Welcome to our seminar on governing documents. This is part of the C.I.A. Services, Associations, and Practice series of videos. In these, we break down important topics into practical, easy to understand insights for community volunteers like you. My name is Ralph Troiano, and I'm very pleased to be sharing this information with you. Our company's been managing community associations in Texas since 1984. These are the topics we're going to cover. What are governing documents? Their publishing requirements under the law. We'll group things into certificate of formation and bylaws, plats and deed restrictions, guidelines, policies, procedures, rules, and regulations, and then finally precedents of documents. Let's start with what are governing documents. Every association has a set of governing documents which are unique to that association. Under the Texas Property Code, these are known as dedicatory instruments. A dedicatory instrument is something that governs the establishment, maintenance, or operation of a residential subdivision. That's the definition under the Texas Property Code. So, for example, the plat establishes the subdivision. The deed restrictions set the standards for maintaining the subdivision, and documents like pool rules form the operating procedures for the community. The Texas Property Code requires that dedicatory instruments be readily available to owners and potential purchasers of property in the subdivision. It defines that readily available in two different sections. First of all, dedicatory instruments must be filed in the public records of the county in which the subdivision exists. If the subdivision is in 2 or maybe even 3 different counties, then all of those dedicatory instruments must be filed in all the counties in which the subdivision exists. Under the law, a dedicatory instrument has no effect until filed. Said another way, if it isn't filed, it doesn't exist. Finally, all dedicatory instruments must be available through any website maintained for the association and available to its members. So it doesn't matter if the association's management company has the website or if the association hosts its own website, the information must be on that website. This indicates that it must only be available to its members, so it's not a requirement that it be available to the general public. So let's get into the documents which are unique to each association. The first two, the certificate of formation and the bylaws, these are about the association itself. The certificate creates the association as a legal entity under the law. It creates that corporation, that nonprofit corporation. And the bylaws can be thought of as the SOPs, the standard operating procedures for the association. When we move on to the plats and the deed restrictions, these documents aren't about the association as much as they're about the land itself. The plat is a map showing the boundaries of the subdivision and how every square inch will be used. It shows the lots, the reserves, the streets, the easements, the setbacks, and so much more. The deed restrictions, on the other hand, describe the use of the land within the subdivision. So that includes the rights, obligations, and restrictions. The rights, the right of owners to have peaceful enjoyment of their land. The obligations, to pay assessments to support the operation of the community. And restrictions on what can or cannot be done on owners' private property. Those 4 that we've just talked about exist for every association. Now let's move on to the things that can be created after the fact by the members or the board of directors. The first important one is guidelines. Now, guidelines are a companion to the deed restrictions. They're about use of land. And because the language and restrictions can't cover every single possibility and every requirement in sufficient detail, guidelines are used to provide clarity as to how a particular requirement will be consistently interpreted or carried out over time. So, for example, if there's a requirement that we maintain our property, well, that's pretty generic. What does it mean to maintain? Does it mean if a gutter is sagging, that's a problem and needs to be taken care of? Does it mean that if there's one fence picket which has broken, it needs to be replaced? There are so many things which are details which guidelines can interpret the consistent interpretation and enforcement of that particular item. Now, in some cases, the Texas Property Code strongly recommends creation of guidelines. It doesn't require you create them, but by the language, it implies that you really ought to. So essentially it says, in many cases in Chapter 202 of the Texas Property Code, it says that a POA may not prevent an owner from doing something. Period. You can't prevent an owner from doing something. However, if the POA creates a guideline, then the POA may regulate that action within the limits of the law. So let me give you an example of that. One of the Section 202 requirements is that, or prohibitions, is that owners may install flags of the United States, of Texas, of the branches of the armed forces on their property. And that's all it says, that an association may not prevent an owner from doing that. However, it does allow an association to regulate that. So, for example, the association could say, you may have one of each of those flags, that they must be respectfully flown, that they may be on the house, or they may be on flagpoles, or they may only be on the house. Those are ways the association can regulate something that is in the Texas Property Code. If an association does not create a flag guideline, then state law says an owner can fly flags and we can't stop them. So an owner could have 1,000 flags in their yard. Under the law, and the association without guidelines couldn't do anything about it. And so under the law, we want to create reasonable guidelines in a way that's still consistent with the law and gives that owner the right to do the things that the law intends them to be able to do. It's important to know that guidelines may not create new restrictions, but only clarify what's written. So if your restrictions don't say anything about parking, then you can't create a guideline that says you can't park on the street. That's not allowed. Only the owners, through an amendment to the deed restrictions, could create a new restriction. And guidelines must have some connection to the existing deed restrictions or the state law. So you can't just create something new. There's some new technology that's not addressed at all in the guidelines. You can't come up with a guideline that controls, prohibits that unless there's some connection to the deed restrictions or state law. And finally, there are policies, procedures, rules, and regulations. These are all related to the day-to-day operations of the association. They can be adopted by the board, and as dedicatory instruments, they must be published to the public and the members. So they can provide decision-making guidance, such as payment plan policy, which would determine what owners can qualify, what situations can qualify for a payment plan. They can cover procedural steps, such as board hearing procedures. What happens when an owner requests a hearing? What information must be provided in advance to that owner? What happens during the hearing? They can cover rules for owners, such as open session rules for board meetings. When is this open session, beginning or end? How long is it typically? How long does a person have to speak? Do they have to sign up first? All of those things which set the rules for, in this case, board meetings. They can cover common area use issues such as parking regulations, pool rules, tennis court rules, splash pad requirements, and things of that sort. The Texas Property Code requires several policies and procedures to be adopted and recorded as a dedicatory instrument. We'll get into those in a different seminar, but the key here is the word requires. When we talked about guidelines, the Texas Property Code implies that you should do this, but it doesn't require it. In the case of certain policies and procedures, they're absolutely required and must be adopted by the association and then published. A couple of those include payment plan policies, access to records policies, hearing procedures, fining procedures, and things of that sort. Our last topic is precedence of documents. With so many laws and documents associated with a community, there sometimes can be conflicts in how one document describes a topic versus another. The concept here is precedence. What takes precedence when there is a conflict? If we have well-drafted association documents, there are going to be few conflicts since each document has its own purpose. If we want to talk about an owner's maintenance responsibility, that goes in the declaration, not in the bylaws. Where we often have conflicts, however, is between Texas law and the declaration, or Texas law and the bylaws. So when there is a conflict, this chart shows you the precedence. Federal law takes precedence over Texas law over the declaration over the certificate, over the bylaws, and then all of those take precedence over anything that we've adopted in policies, procedures, rules, and regulations. I really would like to thank you for watching. We hope this seminar has provided some valuable insights. Be sure to check out more topics in our Associations in Practice series on our YouTube channel.